I'm very often asked the question, how does a lawyer win cases? Because if every case was evenly stacked against each other, then surely there would be no need for lawyers and the court could just decide. So the only difference between having a lawyer and not having a lawyer is surely how the case is presented. So that's what I'm talking about today. But first of all, if you're new to me on this channel, I am a barrister who helps you understand law. So hit the subscribe button and the bell icon, and then you'll get notifications and you won't miss anything. I hold live streams on Sunday taking your questions, and if I don't get round to those questions, I answer them at Black Belt Secrets, linked below. So talking about how a lawyer wins cases, I did another video on how to win any argument, and it's kind of the same thing with subtle differences, but all of it in the reading, the planning, the research and the presentation. So we can break that down into those various categories. First of all, there is the reading. There's a lot of reading. When you get a case, there might be one folder, two folders, three folders, or if you are in a very long trial, a room full of folders. And I'm not kidding. There could be stacks on a trolley, 7 or 8 folders deep, and you might get 5 or 6 different trolleys with all of these documents on. They are usually reserved for the country's most senior barristers, and you will see them wheeling these trolleys in and out of the courts, most notably at the Old Bailey or the Central Criminal Court in London. So reading is number one. You cannot possibly approach a case until you've read everything that is in the case. Most bundles, as we call them, will usually have a nice case summary at the outset, particularly if it's been prepared by a solicitor. It will typically have a table of contents as to what you will find in the bundle, where you can find the statements of case, the witness statements, and then the evidence. And most barristers have their own way of dealing with this. Personally, I like to read the case summary first to get a flavour of what the case is about. Then I will typically go to any statements of case. That might be a particulars of claim in a civil case, and any defences and any responses to that defence. After which I will go through the witness statements of each and every witness to see what each side are saying. On first reading, I just read them through to get an idea of what's going on in the case. Second reading, I will usually go through with a highlighter, and I use a red pen to the side of each paragraph, 1 or 2 words telling me what I find in that paragraph. I will highlight relevant sections of wording, some of which I need to counter, some of which will be in support of my case, and the 1 or 2 words that I put at the side allow me to see what's in that paragraph at a glance, so I can look at a page and I know that that particular paragraph is about the pricing or the contract, when it started, when it broke down, and these kind of things. Once I've done that with each of the witness statements and looked at any of the evidence that is behind those witness statements, I will have an idea of what each side's case is. At that point, and it's tempting to dive into research part way through, and sometimes you can if you're overly familiar with that particular area of law, but usually once you've read the case, I will then jump into research for any special kind of argument that might apply in this case. Because as you often hear me say on this channel, every case turns on its own facts, and there might be that one slight turning point of fact in any part of the case. If that's the case, I will turn up the relevant case law and reread that and apply that to the facts in this case. At least we've still got some summer left. Now, it's entirely possible that the whole case might turn on one very specific fact, which if I can very quickly find some case law for, then that might be the extent of the research that I need to do. Because if you can apply a very authoritative decision to that case, that might be all you need to win the case. However, as I often say, it's not usually that straightforward. There are usually a combination of different facts and factors within each case, so you might need several different authorities to apply to each and every one of the aspects of the case that you need to argue. That means a lot of research both on legislation and on case law. And how do we go about doing that? Well, very often there are practitioner texts for various different areas of law, and each practitioner will usually have access to a library copy of said text, or multiple texts if you are a diverse practitioner such as myself. Once you've established what the case is about, what each party are saying, what your potential arguments are, you've done your research, you've found the case law, any supporting legislation, any authoritative cases that will help your case in one way or another, then it's time to go about planning how this case is to be presented in court. This is twofold. One, it is presenting the case as a factual sequence of events, which you can show what happened and when and why the legislation or the case law support your case or contradict the case against. And secondly, you will have witness evidence coming through which you need to challenge in various aspects, because you might not like some of the witness evidence that comes through which will contradict your points of argument which make your case. And this ultimately is where the real advocacy of being a barrister comes into play, because when the day comes and you are in court, you need to take all of your case preparation, which includes all of your notes, your case law and everything else. It will include a skeleton argument that you've probably submitted to the court beforehand, detailing to the judge what the outline of your argument is even before you make it. One of the best things that I was ever told during my training is to get a very good and comprehensive skeleton argument into the judge, even if the rules don't require it for that particular hearing, because the judge will very often decide a case based on the skeleton argument, but then of course only change their mind if the presentations sway them in one way or another. So then it comes to witness evidence in court by itself. Now, in civil cases, your witness's evidence will usually be contained within their witness statement, although sometimes you will ask additional questions, usually with leave or permission of the judge, to ask additional information that was not contained within the witness statement. And in turn, once each witness's evidence has been accepted by the court, the opposing side has the opportunity to cross-examine that witness and essentially put the contrary case to that witness and invite them to concede inaccuracies or inconsistencies in their witness statement, or simply to put to that witness for an opportunity to respond that they are mistaken or incorrect. This is a requirement of the rules, in fact, because if you want to say to the judge or to a jury that the witness is mistaken in part of their evidence or plain wrong, then you need to give that witness the opportunity to respond to that. And to give you an idea of how this might come across if you are the witness being cross-examined, one such witness that I was cross-examining just recently said, "It sounds like you are telling me what happened rather than asking me what happened." And in effect, that is exactly what's happening, because aside from me highlighting inconsistencies and inaccuracies of that witness's evidence, I am putting to that witness my client's version of events and giving them an opportunity to respond to it. So in other words, I will say, "It wasn't at this time, was it? It was at this time. And it wasn't this much, it was that much. That's right, isn't it?" So I'm putting those across as closed questions, which can seem a lot like statements. But in effect, that is part of the advocacy, and that is how cases are presented in court. So then, of course, once you understand all of those stages, it's a matter of doing this for many, many years to become more proficient, more persuasive, and ultimately, that's how a lawyer wins cases. Give this video a big thumbs up if you enjoyed it, and remember, stay humble and subscribe.